Good morning.
Good morning.
I'm Jeremiah Steffen with the Attorney General's Office. So we're going to talk about calculating child support and modifying child support. I know about half of you already, so this doesn't need to be a lecture. We can just sort of talk. You can ask me questions, you can interrupt, you can make fun of my slides, whatever you want. Also, recently I bought a drawing tablet for my kids. So it's this fancy pen and tablet that you can draw on. And it'll actually make drawings right on the computer for you. And I might have gone a little crazy with it when I was creating my slides. So if you see something with a ton of circles and a bunch of arrows driven all over it, that's kind of why. So keep that in mind. So I thought we'd just jump in right away and just talk about the general formula to start. And I'm going to try and leave out all the legal jargon that I can. And we'll go through the basic calculation first, and then we'll go step by step through each part of the calculation, and I'll go into much more detail. And we'll jump into the statute itself, and I'll point out what I think are the important language parts of each section of the statute. And then at the end, if there's time, we'll talk about how to also calculate contributions to health insurance. But I'll leave that as kind of a buffer in case I run out of time. So let's just jump in and talk about the basic calculation. So remember, this is income share, so we're using income from both parents. So father, mom, and dad. And we're going to start by using gross monthly income. So the income that they make before taxes are taken out, before insurance premiums, before rent, all that stuff. In a perfect world, this is how much money they would actually be putting into their pockets. Then we're going to take out taxes. And as I'll show you in a few minutes, there's two ways to calculate taxes when it comes to child support. Individualized and standardized. One uses a chart, one uses their actual tax return. We'll go over that in detail. But that is a deduction, because we're removing income that is not available to actually support the child in this case. After that, we're either going to add in or subtract out maintenance. There's two ways to do that as well. The key date is January 1st of 2019. So if it was established, the maintenance obligation was established before that date, we add it to the gross income. After that date, we add or subtract it to net income, and I'll show you that as well. After that, we account for other children. So whether you have a child support obligation in a different case, or you have a child living in your home, or you have a child that's in someone else's home and you're voluntarily paying support, that is also reduced from gross income. Then we get a net income for both parents, and we add them together to get a combined income. So when I'm explaining this to pro se litigants, I like to say this is their hypothetical combined income, because chances are it's a lot less than this. But for child support purposes, this is what we're going to pretend the family has access to when we calculate child support. After that, we're going to figure out our income split. So we're going to take mom's share, or net income, and we're going to divide it by the total amount of income for the family, and we're going to figure out the percentage share. And we're going to do the same thing for dad, right? His net income divided by the family's total income, and we have his percentage share. And then we go to the last step, which is combined support amount. So for that, we're going to look at the combined income for the parents, and we're going to go to a chart that HFS issues, and we're going to find their income on the chart. So you'll see that they fall into this category right here. And in this hypothetical scenario, we have one child. So we're going to look at that individual column. And we see that for this family, they should both be spending $855 each month to support this child. So that's for the essentials, right? Housing, clothing, and food. Dad doesn't pay the full amount, though. He pays his percentage share, because this is an income share statute. So we look at his percent of income. Well, we're going to calculate mom's this way. We do mom's, even though she's technically not ordered to make a payment, but we do this, I think, more for a negotiating tactic. So we can tell dad, hey, mom's paying her share too. So in this scenario, she's paying 52% of the combined support amount. So that's $445.11. And I guarantee she's spending more than that on a monthly basis to support the child. And we're going to do the same thing for dad. So his percentage share of the income, 47.94%. We're going to multiply it by that combined amount that we got from the chart, and that's how we get to dad's child support amount, which in this scenario is $409.89. So I hope that makes sense. I'm going to go through each section of that a little bit more in detail, but does everyone get kind of the basic gist of how we're going to calculate child support? Okay, then I'll just keep moving on, but please interrupt me. The first thing we're going to talk about is taxes. How do we take out taxes? So this is going to be our first scenario. So mom has $3,000 gross per month in income. Dad has the same, just keep it easy. We're going to use the standardized net income, but I'm going to show you how to do individualized. We're going to have one child, and we're going to keep it really easy. So in this scenario, no maintenance and no other children. So just one kid, two adults with the exact same income. So let's just go through our formula really briefly. We have $3,000 gross income per month for a mom, same thing for dad, and for taxes we got to figure this out. So as I mentioned before, taxes has two ways of calculating it. You can do standardized or you can do individualized. Standardized, I think, is basically for me and my colleagues, right? We're doing high volume polls, or we're dealing with a lot of people very quickly, so we're going to use the chart because it's very quick and easy to determine someone's tax obligations. For you, if you have a smaller call volume, I would strongly suggest you at least look into individualized. Because standardized only says that the person is single, they're not married, they don't have other dependents, they're claiming standardized tax exemption, deduction, and they have one personal exemption. That might not be true in every scenario. Chances are it's probably not. So you want to look at their last tax returns and figure out which is the better scenario, because you do want to give them credit for all the taxes they pay. Individualized, as I mentioned, you're going to look at all of their taxes. And this is most important if the person is self-employed, because they're going to be paying more taxes because their employer is not matching their FICA, their Medicare and Social Security contributions. So look at their taxes, see what they're actually paying, and then prove that up to the court so you can get them that deduction. But because we want to keep this really easy, I'm going to use the standardized net income in this scenario. So we're going to go to HFS's website. It looks like this. You're going to click on the button down here. It's going to take you to this page with all the child support information on it. And we're going to go to the gross to net tables. And they just issued brand new tables in March. So make sure you have the most up-to-date tables. This is what it looks like. I've circled 2019 in the top left-hand corner because you need to make sure you're using the right tables. The old table had a bunch of columns on it, depending on how many children you actually had. Well, we no longer do that. In this scenario, we just have two columns, one for mom, or one for the custodial parent, and one for dad. So we're going to find the person's gross income on the slide, and it's going to correspond with either the left or the right column. So on the left-hand side, we have the person who is receiving child support. And you'll notice that in this scenario, mom's taxes are slightly less than dad's, right? Mom is over here at $2,410, and dad is over here at $2,368. That's because we're assuming by using the standardized charts that mom's getting the child tax exemption. I don't know. That might not be true in your scenario, which is another reason you got to look at that individualized amount. But in this scenario, we're going to say mom, after taxes, has $2,410 available. So we're going to stick that right on our calculation. And we're going to do the same thing for dad. Remember, we're using the right column because it's the parent with the duty to pay support. So his income after taxes is just slightly less. So now we have our two obligations. We're not going to do maintenance in this scenario. We want to keep it simple. We're not going to do the multi-family adjustment in this scenario. So we're not going to count for other children. So all we need to do is drop down our net incomes onto the adjusted net income line. So we know what we have for mom. We know what we have for dad. We're going to add them together. We're going to figure out the split in income, right? So how much mom has after taxes divided by the total income. Same thing for dad. His income divided by the total income. And then we're going to go back to that chart. And that's available on HFS's website. It's right here. It's called the income share schedule. It looks like this, right? So we're going to find their combined income right here on this line. And we know they have one child. So their combined amount in this scenario is $921. That's supposed to be how much both of them is spending to support this child, for the child's basic needs. And then we just do our math again, right? We're going to divide the total, 921, their combined support amount, by each individual's percentage share. So mom has a little bit more than 50% of the income, so her support is going to be $456.45. Dad has slightly less than 50% of the income, so his support is going to be $455. Ooh, maybe I made a mistake. What do you think? Well, it doesn't matter. You get the general idea, right? You're supposed to take 921 multiplied by 4956, and I bet it's a slightly less number. But I think you get the general. So that's how we calculate support after taxes. Does anyone have any questions about taxes or how you actually do it in the courtroom or anything like that? What the statute kind of implies is that you're supposed to be either asking for permission from the other side and entering an agreed order saying you can do the individualized amount, or actually making a request to the court. I've never seen that actually done. Typically when I'm doing these cases, attorneys will just bring in a printout from a family law software showing what the tax obligations are, and nobody really questions it. But if you have a really aggressive council on the other side, you might want to motion this up just to be super careful to allow these individuals. And I don't know if anyone's had maybe any experience with that. Do we feel pretty good about taxes? I mean, it's not super complicated. Yeah.
I guess sometimes I see clients who have got a small amount of rental income, and basically, like, it doesn't make sense to look at it in terms of a gross amount because your gross rents just aren't anywhere close to your net rents. How is that usually dealt with?
Yeah, so I think it would be considered business income. There's a whole portion of the statute to deal with business income. I think you'd have to turn over receipts and everything to the other side and prove up what you think is the accurate amount of actual income. Generally, in my case, when I see someone who has rental income, and it's pretty rare, but I do have a couple, we're going to use the receivables. We're going to use how much rent they're receiving unless they can prove to the court that they have other expenses associated with that property.
So even though, for the most part, people, their tax returns will show like a very small amount of net income from their rental income. And in my experience, like county judges are just like, well, that's good enough.
Yeah, I mean, I don't think you're going to have an issue unless the other side is going to make us think about it. And then if they do, you're just going to put your client on the stand and say, how much rent do you make? What are your other bills? Hopefully you'll have some tax returns or some receipts to prove that up. I don't think it's going to be an issue, but I do think it's dependent on who's on the other side of the case.
Yeah.
Most of the cases I handle, it's not an issue at all. We look at the paperwork together. If we need to, we get some testimony and then we're done. Because chances are the rental income is not a huge number, so it's not going to tip the scales tremendously in one side or the other. Unless you have someone who's got a lot of income.
Well, but it will if you disallow the depreciation.
Right, and that's what I'm saying. If you want to, you can fight this, right? But I would always run the calculation first and see if there's anything really necessary to fight about. Because a lot of times when I see us adding a little bit of income or taking away something from the net, we're talking 10 to 20 bucks a month. At least in the cases I handle. If you might handle larger cases, Gary's not handle that. Is that kind of your experience though? You've thought about rental income?
Right. The first thing to happen is, we've got a two-unit building and we're renting it out and we're showing a loss of $5,000 a year. Well, if you forget about the depreciation, now we're positive $10,000 a year. And then you go through, it's like dealing with any self-employed person. You take out all the personal crap that they run through the business, and now we're up to $20,000 a year. And it can make a sizable difference.
And that's when you got to take in front of a judge.
Right.
The only rental properties I've ever had in my case is generated a couple $100 a month in income, and it just wasn't worth fighting over, especially because the parties reached an agreement about it. But I think Gary has much more larger cases than I do, so you're going to have to fight that.
In those situations where you do have somebody who has maybe one or two rental properties, and so it is small, but the custodial parent is kind of insisting that it be taken into consideration, do you have to do your separate analysis under the business income portion of the statute, or do you just tack it on to dad's gross?
I think you have to do a business in that case,
Right.
right? Because there's a lot going on there. But you have to remember the kind of cases I handle.
Oh, sure,
There's
yeah.
just not a whole lot of rental property. There's not a whole lot of income, period.
Yeah.
So I don't have to deal with this stuff. So, I mean, maybe Gary would be a better person to chat about it. If you don't mind me just...
That's okay.
Put your phone number on
In addition to contempt, I can tell you.
Yeah, just come back to that.
Much more basic question, and I know you ran through this. The reason they have different net income after taxes is because of the...
Because we're using the
Tax
standardized
credit.
chart. Let's see if I can get all the way back to it.
And because mom in this situation gets the tax credit.
Yeah, we're assuming by the chart that mom's going to get that deduction. And you'll see there's not a tremendous difference between the two numbers,
Yeah.
but that's why. That's why there's a little bit of a discrepancy.
Okay.
Does that make sense? Let me just flow through all the slides one more time. Is it okay if we move on to maintenance? Okay. So we're going to keep the scenario pretty similar, right? But this time we're going to say mom is going to pay dad $400. Dad is going to pay mom $400 a month in maintenance. We're still going to use that standardized net income. They're still going to have $3,000 a month in gross income, no other children, and one child. So things change slightly, but you'll see that the math is still pretty similar. So mom's got $3,000 in gross income each month. Dad has the same. We're going to use that standardized chart again, right? So we have the exact same income, so the chart is identical. But we're going to find the incomes, right, in the range right here. We got mom's net, we got dad's net, and we're going to stick it on to our calculation. I'm going to go a little bit out of order, but we're not going to do the multifamily adjustment in this scenario. So we're not going to count for any other children, just so we can focus in only on maintenance for a second. So dad is paying mom $400 a month in maintenance. And I talked about this really briefly before, but the question you need to ask is, when was the obligation established? Because it really depends on that date. If the obligation was established before January 1st of 2019, you're adding or you're subtracting from gross income. If it's on or after January 1st of 2019, then you're adding or subtracting from that. I gotta be completely honest. I had had one maintenance case in the entire 3 years I've been doing child support for the AG's office. So I'm by no means an expert on this, but it is something you need to know, especially because you're probably going to be doing much more contested cases that maintenance might become an issue in. So I ran the calculation twice, once doing it before and once doing it after the date, right? And you'll see that I added the $400 to mom's gross and I subtracted it from dad. And we run the calculation the same way we have the last 2 times, and we get down to dad paying $398.33 in child support after we make that switch to the maintenance. In the second scenario, we're not adding it to gross. We're figuring out their tax obligations, and then we're incorporating it into the statute, into the calculation. And you'll see that the adjusted net has changed, right? Mom has more than she did before. Dad has less than he did when we did the before calculation. But we still arrive at virtually the same number at the end. So that means that our basic support number, 921, from that chart remains the exact same, because we're using their combined income to go to that chart and figure out how much they're supposed to be spending on this child on a monthly basis. Right? And the numbers we get at the end are also very similar, because we're just shifting money back and forth between the parties, and their percentages aren't changing that much. So if you blow the incomes up a lot more and we inflate maintenance a lot more, you are going to see a more dramatic shift in the child support amount. But I think the basic point here is it doesn't tip the scales tremendously. So you have to keep that in mind.
What was the reason for the adjustment after January 1st?
Because of the Trump tax changes.
Maintenance is not tax deductible after January 1st,
Right.
2019, unless the order setting it predates that.
So this is just the state law coming into line with what the federal had already done?
I believe so.
Okay.
Yeah, and I think Gary's right. You can't say that. Let's not make it overly complicated. I think the date is important when the establishment happens. Then you know that you're going to have to adjust your child support calculations. We feel pretty good about maintenance. Okay, it's going a lot faster than I thought. Let's talk about multifamily adjustments. This is something I deal with a lot, so I feel much more comfortable talking about it. What we're doing is we're accounting for other children. So children where you have child support over for that you're paying on in another family, children that live in your house, or children that even live in another house but you're voluntarily paying support on. And I see these in probably 80% of my cases. So we're going to keep the scenario pretty similar, right? They both have that $3,000 a month in gross income. We're going to continue to use the standardized net amount. No maintenance. We're going to take that out to keep it simple. Now we're saying that dad pays $270 a month pursuant to a court order, and mom has 2 other biological children that are living in her household. And we have 1 child in this case. So now we're going to adjust the math a little bit. So $3,000 gross per month for both parties. We've already done the standardized net a couple of times, so I'm not going to bore you with that. We have that. We get it directly from the chart. We're not going to deal with maintenance. And now we're going to just talk about the multifamily adjustment, right? First part, dad pays $270 pursuant to a court order. Mom has 2 other children. So let's talk about dad first. Here's a section of the statute, and here's what I think is important. I'm not going to read you all the language. I know you're smart enough to read the statute, but 2 things you have to keep in mind. 1, are they actually legally responsible for this child? So no stepchildren here. No, my boyfriend has his kids living with me. That does not count. You must be legally responsible to financially support this child. So you need to dig into that a little bit. Also, are they actually making the payments? They might have a child support order. That's great, but are they actually paying? I think the best place to go is the STU records. Most of my cases use the STU. Some of yours might. So you need to insist on payment records to see that they're actually making the payments. Now, my own personal preference is they don't have to be perfect. If they're missing an occasional payment, that's not a big deal. But I do want to see regular payments before I'm going to consent to allow them to get this deduction from child support. Also, there's a little bit of language in here buried that I didn't highlight that I also think is important. And it's the last sentence that says, unless the court makes a finding that would cause an economic hardship for the child. I actually see this quite a bit in my cases because I have individuals who have multiple kids with multiple families, and when you stack all their obligations on top of each other, we get to an amount where they qualify for a minimum child support, which we'll review at the very end. So essentially, they're not paying any child support. So depending on the scenario, I will make an argument that dad has made choices in his life to have lots of kids with lots of moms, and that should not negatively impact the child in this case. But that's a determination you'll have to do with your judge. People are not going to waive the right to deduct child support that they're paying. So in this scenario, let's
Can you talk a little bit more about that and your success on that argument?
Yeah.
What kind of facts you bring in?
Sure. So, see, my worst one I've had lately, dad had 13 children with 10 different moms. So that is a lot. He was making the best he could out of it, and he was actually making payments towards his obligations, but there's no way he can make payments on 13 children, right? And he's having more, too. So I just put it out there very, very bluntly to the court that he's made these choices, and I always advocate for the state. I'm saying the state should not be on the hook for his poor choices. And that went well with my judges in whatever county I was doing that. In other scenarios, you know, I'll just point out what I think support would be if we didn't give him that deduction and what it would be. And I'll talk about with the judge very briefly, either through testimony with mom or I'll just say this in argument. Like how much $100 a month is really going to go towards supporting a child? Because that's usually what we get down to. Right, we're getting down to nominal amounts, either $40 a month or something really low. Like dad's paying $100 a month, that's not even food. So I'll stress that point. And I think that's really persuasive to a judge. Because they do want to see what's best for this child, and they don't want to get daddy. So that's kind of what I focus on. Yeah.
You can also be creative, and it's part of what I'm going to talk about later. I sent a guy to jail once because he was spending more per month on cigarettes than the child support amount.
Yeah.
So you got the guy with 13 kids. I'm willing to bet that he has a couple six-packs a night and he smokes a pack and a half a day.
Or something else.
And if he can afford all that stuff, you know, let him stop smoking and support his kids.
I agree. I tried a case in LaSalle this Tuesday where dad wanted to reduce his support down. He's paying $37 a week for 2 kids, and he wanted to modify it down. And I always ask these guys, well, do you want to modify it down to 2? And his answer is always, I don't know, maybe $10 a week. And then I asked him what he spent his money on, and he said cigarettes. And I asked him how much a pack of cigarettes cost. He told me $8.25. He says he smokes a pack a day, so we just did the math. That's $56 and some change. A week, he can afford child support. And that's super persuasive with a judge, because you can quit smoking. Eventually, it's hard, but you can do it. But I think it's a great argument to make. I also like to talk about tattoos. Most of the people I do child support with have really nice, elaborate sleeves and neck tattoos and even face tattoos. Those are not cheap. They can afford things like that, or really nice sneakers. They can afford to support their children. So I think that's all fair game. And you should be bringing that into your arguments. This one's pretty easy, though. I mean, if you're making payments on the support amount, you should probably get the deduction. And you're probably not going to win if you fight. Let's talk about the other scenario. This is where a mom has 2 other children, right? And remember, the statute says that they can be living inside her home or outside her home. But we have the basic parts of this that I'm going to highlight. It's got to be actually supporting the child, right? So you're going to need some sort of proof. Generally, that's testimony. People don't keep receipts for the amount of money that they spend on their kids. But I would ask for some sort of proof. And remember, it's a child living in or outside of the parent's household, which I think that doesn't make a tremendous amount of sense. But outside the household, it's generally meaning they're voluntarily supporting this child, which is a great thing. But they still need to prove it up to the court, right? So I would ask for at least testimony under oath. But I probably want to see some receipts. Some of the guys I work with do actually have money order receipts, so they can show at least a little bit of a paper trail for what they're providing to the child. Or they'll bring in receipts for strollers or other things that they've been purchasing, and we'll take that into account. Let me just skip ahead real quick. It's supposed to be the lesser of the 2, right? So what they're actually spending, or what support would be if we based it only on their income, and then 75% of that. So you really have two options, and remember, it's supposed to be the lesser of the two options. So if they're actually paying, you're going to want to see receipts, or you're going to see testimony, or if we're going to use the 75% amount, then we're going to have to calculate support just for them all over again. But it's a little bit quicker. We take their net, we go to the chart. Remember, we're only using their net. We're not adding it in with the other parent, because this is a child outside of that relationship. In this scenario, we're saying mom has 2 kids. So we're finding her net income on the chart, along with the corresponding column for 2 kids. That's $788. We're going to do some basic math, which is 75% of that. How I usually explain it to people is, we're assuming that there are shared expenses for this child, because either the child is living in your house or living with another parent. So you don't get a dollar for dollar deduction because you're sharing this expense either with yourself, because you're under the same roof, or with another parent. Let's assume, though, that mom is actually doing what she's supposed to. The 2 kids are living in her house, and she should get this deduction. This is how we do it. 7088 times 75%. So now she's going to get a deduction for $591 a month. Does that make pretty good sense? Then we're just going to keep going with the calculation. So we're going to give those deductions to both parents, further reducing their net. Remember, what we're trying to do is figure out how much income is actually available to this family to support the child. So we're taking money away that they're spending legitimately in other places, in taxes, maintenance obligations, or other children. So we've reduced their nets down. We're just going to do the same calculation again. We're going to add them together to find the combined support amount, figure out their percentages by dividing their net from the total, go to that chart. We have 1 child in this case, so we go to the chart, find the combined income on the chart, and we have $824. Remember, this is for the basics: housing, clothing, and food. And we're going to divide that by the percentage that each parent has. Again, I always do both parents, especially when I'm doing this in front of people, because it makes dads feel a lot better when they see a number down here for mom. Again, I think she's spending way more than $380 to support this child, but at least dad sees this on the sheet that you're doing either in the courtroom or that you've printed out, so he feels a little bit better. And then we get to the final child support amount, which is $441.33. So there's a lot here because it's really dependent on whether or not they're actually spending this money. Yes, sir?
Yeah, I have a question. It's a lot of quick process. So that 591 in mom's column,
Yeah.
that comes from where again?
Sure. It's a good question. So remember, we have 1 or 2 options: what she's actually spending, or if it's less, 75% of what child support would be based on her income.
Well, okay, so slow down. You say child, so these 2 kids are living with her, correct?
These 2 kids are living with her.
Okay, so go back to the last slide where you had all the numbers.
You want the last one, the very end?
So that 382.67 in her column,
Yeah.
that's her share of support for this 1 child, right?
Yes.
Okay, so is that 591 coming from that spot on her other child support case?
So I've done this. Maybe I should divide this out into 2 separate scenarios. $270 for dad is from his child support order in the judge's order to pay $270. Mom doesn't have that. In this scenario, mom has 2 kids living with her in her house. So we go to her net income. Based on her net income, we're going to go to that chart that I showed you for the basic support obligation. Only her net income. Right? I'm going to pull the slide. Right? It's easier for me to talk. So here's the slide. Well, no, that's not the slide.
So where does that 788 come from?
78 comes from the chart, right here.
Okay.
So we're finding her net income on this chart. She has 2 children, so we're finding 2 children on the chart, and it corresponds with 788. Then the statute says she does not get a dollar for dollar reduction. She gets 75% of that. The rationale being, she does share some expenses with this child. They're living in her house, right? So they share rent, hopefully they share food, other things.
So it just comes from the chart. It doesn't matter whether she's getting child support for those 2 other kids.
Whether she's receiving?
Yeah.
It's totally irrelevant when we talk about child support, because that money, if you think about it, is supposed to be for the children she's receiving support for. It's not part of her income for child support purposes. Does that make sense? I'm sorry,
Well, I understand it now. I mean, politically, I don't know if it makes sense, but yeah.
Well,
I understand it.
I can talk to that, right? But yeah, you can debate whether or not this makes sense overall. I do think that it is a good idea that we're at least trying to account for other children in these people's lives. And I've run these numbers a lot, to be totally honest. they're pretty close to the old statute in most cases. You're not getting a huge different number. At the upper income levels, I do think things have changed. But at the lower income levels that I deal with, dads are actually paying more now than they were before, even with these sort of adjustments. You feel good? I'm happy to keep talking about it. I don't want to go too fast.
No, well, I have this quote. So, on that, I understand a little bit more now, thanks.
Sure.
Yes.
Okay. Kim?
So if our client who has some foster kids living in her house right now, and I think she probably gets some money from CFS for them, would those count as a multifamily adjustment for her, or only if she adopts them?
Only if she adopts,
Okay.
right? You gotta remember, that money again that she's getting from the state is for the children, so we
Okay.
wouldn't include it in her gross.
Yeah, I figured that much, but whether or not they count as multifamily adjustment.
Not if they're foster kids.
Okay.
If they're
She's in
adopted
the process
children,
of adopting them, but it's not finalized.
then I don't think she gets that deduction. You could work it out with the other side if you think it's important, but
Not with the individual counsel in this case, but
think I know who it is, so.
probably.
All right, so I like the multifamily adjustment. Maybe politically we don't agree with it, but it does give you some leeway to adjust these numbers and play with them a little bit, right? And it gives you some little bit of ammo too if you need to fight somebody a little bit, because you can give this back to inflate the numbers. But trust me when I say, if it's just dad paying $270 a month and that's your only deduction, it is not going to tip the scales that much. But it will make him feel like justice has been served if he gets that deduction when you calculate his support. So I think it's important to talk about it.
This is kind of an open-ended question for everyone who does this, but say you represent dad and there's minimal income and dad does have other children he's paying support for, there's receipts for it, but it's, he has not established paternity in any way. Would you advise him before you seek modification of his support to establish his paternity for these other kids that he's paying support for?
I would always tell dad, you need to be in court to get this done, right? And if I'm being honest, I would give him the deduction in my cases. I'm not going to deny someone who's actually supporting other kids, and unless I see a reason that maybe this isn't legitimate. Usually it's just a vibe, like I get a creepy vibe from the guy, and like, there's just no way you're actually doing what you're telling me to do. And then I'll ask him to, actually present testimony and do it under oath. But if he doesn't have like a judgment of paternity or a DNA test or something, I'm not going to give a tremendous amount of pushback. If he has receipts and he's really proving it out. I'll also talk to mom too, and generally she knows that he's got other kids and he's actually doing what he says he's doing. That's how I would handle it. I bet people in this room handle it a little bit different. All right, so we got multifamily adjustment. Now let's make things much more complicated and talk about parenting time. Our magic number is 146 overnights a year, and it must be exercised. That's the important bit of the statute. So if you've been awarded 40% overnights, that's the 146 number, but you blew it off and you haven't seen your kids in 2 years, too bad, you do not get the deduction. But if you are exercising those overnights, actually seeing your children at least 40% of the time at your house, you're spending the night, then we got to do more math together. So let's talk about the scenario. I'm trying to keep things generally the same so that all the numbers don't bounce around. Yeah.
Just one question, especially with the 146 overnights. Do you provide those slides and get them somewhere? Because I deal with that problem
What do you mean?
with the 146 overnights.
Yeah.
So that's a part that I'm especially interested in. So I just wanted to know if you provide the slides.
Oh, I can do the slides. I can email it to you. I think the best thing is part of the handouts that I gave out, there's a shared parenting worksheet that you should have in front of you. And on the left-hand side, there's just instructions on how to do it. And it's a little tedious, especially the first couple of times, but it just basically walks you through the process. It's what I'm going to do right now. But if you like, I'll give you my email address. Just email me. I'll do the whole thing. Okay? All right, so let's change the scenario up just a little bit. So income remains the same, standardized net remains the same. We're not going to have any maintenance for other children because that just makes it too complicated. One child, but all we're changing right now is dad is exercising 146 overnights per year. So we've got 40% of parenting time. So I'm going to skip through the calculation. I'm not going to do the whole thing all over again with you. Right, so we do know how much dad is supposed to be paying if he didn't have the 146 overnights. That was that $456 amount we calculated a couple times together so far. Now we're going to keep going. So we're going to start with the basic support amount. Now remember, this was for the essentials for the kid: housing, clothing, and food. Now we have 2 full households technically, right? The child is spending a lot of time in both parents' households. So now we're going to increase that number by 1.5. The idea being, now we need to maintain 2 households with a bedroom set and toys and all kinds of stuff, so the parents should be spending more money. So we're increasing that floor all the way up to $1,381.50. And all I did was take 921 straight from that chart and multiply it by 1.5. After that, we're going to keep going. So we're going to take, this is where I got kind of crazy with my pen. We're going to take the new shared support amount and we're going to multiply it by mom's percentage share of the income. Remember, we calculated that by taking her net and dividing it by the parents' total amount of income. And in our scenario, it was about 50%. So we're going to take 50%, and we're going to multiply it by the new shared support amount, and we're getting a new monthly child support obligation that she should be paying. I kind of do this here, right? Do the same thing for dad, right? The new shared support amount multiplied by his percentage share of the income, and now we've increased how much he should be spending each month on this child. But we're not done. So now we need to figure out what percentage of time each parent has. In this scenario, it's really easy, right? I'm saying he's got 146, that's exactly 40% of the time. But in your cases, it's probably not going to be that perfect. So you're going to have to take the number of overnights mom has, divided by the number of overnights an entire year, and figure out your percentage. So I've done that here for mom, and I did it here for dad, right? So all I'm doing is taking the number of overnights he's exercising, dividing it by the total number of days in the year, and figuring out the percentages. And then we keep going. So now we're going to take, well, we're going to cross multiplication. Keep this in mind, right? We're taking the amount of money mom is supposed to be spending on a monthly basis, and we're multiplying it by the amount of time that the child is in dad's house. If you think about it, we want her paying support for the time that the child is with dad. And we want to do the same thing with dad. We want dad paying an amount of support equal to when the child is with her. So that's why we're cross-multiplying. We're multiplying mom's total by the percentage of time dad has the child, and we're getting to a new shared amount total. Does that make sense? And we're doing the same thing for dad, right? His new monthly support obligation multiplied by the amount of time the child is with mom gets us to his new support obligation. Okay, so we're just taking out money. We've already done that for things like the multifamily adjustment, maintenance, and all that stuff, and taxes. Now we're taking out more money because the child is now with a different parent for a significant amount of time, and we don't want that party paying support while the child is with that other parent. But we're not done. We got one last step. Now we're going to find out what the difference is, right? We're going to take dad's obligation, we're going to subtract out mom's obligation, and we're going to have a difference. Now, in this scenario, the difference still has dad paying mom, right? Because his support amount is more than mom's when we go through this entire calculation. But it's very possible, if we have a discrepancy in income, that now mom has to pay dad, even though dad only has the child 40% of the time. It doesn't happen a lot of times in my cases, but it is possible, and you need to keep that in mind. So now we have dad's support obligation. It's been reduced. I think I made a mistake on the slide. This is supposed to be $445 or $54. But you see that we've reduced income substantially to account for the amount of time that the child is with dad. If he reaches that 146 overnight amount. So he's got 145 days, he does not get the benefit of this calculation. He's got to reach that total, and he's got to exercise it. I can't stress that enough. Guys come in all the time saying, I have a 50-50 parenting split. I'll ask him on the stand, how often do you see the child? Will say, I think I saw the kid once last month. That's not good enough. He's got to have the child on a consistent basis. Does that make sense? It's a lot. I got to be honest, this did not sink in with me until I did it 3 or 4 times in the courtroom, not just, at my desk doing it real easy. Yeah, sure.
Have you had a lot of these where dad has the kids allegedly 40% of the time, but 70% of his 40% is time spent with grandma as opposed to time spent with dad? We're getting more of these lately because of this.
Yeah, so it depends what county you're in, right? In LaSalle, they're going to require you to have a parenting order first, then prove up your parenting time. Kankakee, where we work together, they don't really care so much about parenting time orders, right? So it's going to be about testimony. I got to be honest, I would have to put the parties on the stand, and I would insist that both mom and dad testify in that scenario, and I would just throw it to the judge. I would punt it. Because I don't know. Yeah.
And call grandma too?
Maybe. I have never called a witness like that in any of my cases, right? I'm not going to choose something else. I've way too many cases on a call at the same time, but I think that would be a wonderful idea. The child's not with mom. The child is with dad and his family, and you would qualify for this even if the children were in daycare all day. So I think dad gets the deduction in that scenario, but I think you got to take some testimony and make sure that what people are telling you is the truth. And I really do think that's what the judge is there for, to make that determination whether or not it should fly or not. Yeah.
Well, how does that work with the program? Because correct me if I'm wrong, if dad has 146 nights because his lawyer fought for it in the order,
Okay.
but 100 of those nights is being shipped off with grandma. And so we put on testimony, say he shouldn't get credit for that, okay? So we should knock off those 100. But what's problematic is we don't add the 100 to the mom because she doesn't have them either. So if I plug in those numbers, if I plug in 46 for dad, it's going to shift that 100 to mom on the computer program, right?
Right. So when I have cases, not exactly like this, but where we have multiple scenarios, you have to do it by hand. The program's not going to help you. And you're going to have to submit several different calculations to the judge. At least that's how I handle it. I still think the child is not with mom. The child is with dad and his family. And hopefully he's doing the best he can, working nights or something like that. I think he should get a deduction. If you don't agree with me, I think you've got to put it in front of the judge. That's why they make a lot of money. I know it's not a great answer, but that's what I got.
I get it. It's the reality of the situation, and the example you gave, I guess illustrated what if he's working nights and that's his daycare.
Yeah, which is legitimate, right? And if it's a problem, then you can go after him for daycare expenses for mom. I mean, there's always another way to get him in the gut.
GPS signal lost. Because I'm here.
So if I were you and you haven't done a lot of these, just sit down and do a couple of them. Make up some numbers. Do it yourself by hand. I'll show you how to use the HFS's calculator in just a second. Do it through the calculator. Just get comfortable. It's weird when you have to do this on the fly. It's a lot of steps. When you're doing it under the gun, it just doesn't feel natural to do that cross multiplication. So get comfortable with it, and then I think you'll see that it's really no big deal.
Chairman,
Yeah.
I don't know if you covered the rationale behind the 1.5 multiplier, or it says it in the statute, or does it
It
exist?
does not say in the statute. This is my own sort of feeling on it. We now have two legitimate full-time households. Dad has the child 40% of the time, the child's around or something. So they both have to have bedroom sets. They don't have to feed the child. They have expenses that they're sharing. So that's why I think it makes sense to increase that floor, that shared support amount by 1.5. I've never seen any rationale anywhere for it. I guess you could go through the legislative process. It makes sense though, right?
Yeah.
Because if we don't increase it by 1.5, then support's going to be minuscule, and that doesn't make sense.
And you see it in a divorce context, just the cost of maintaining two households as opposed to one.
It's a lot,
Outside
yeah.
of children, yeah.
Though, to be honest, even if dad only has every other weekend and Wednesdays, he's got to maintain another household too. It's not like that money just doesn't get spent. So I think the 146 is just the number we chose. It makes sense. So let's talk about another scenario, split custody. All right, so in this scenario, we're going to increase mom's income a little bit because, as you'll see, if they both have the same income, then we're basically going to have a $0 support line. So now we're saying mom's doing a little bit better for herself. She's got $5,000 a month in income. Dad's a little lower, $3,000 a month. We're going to keep everything simple, standardized net, no maintenance, no other children. Now we have two kids. One's living with mom and one's living with dad, which is a lot more common these days than you would think. So we're going to do 3 steps. First, we're going to do a child support calculation to see what mom would pay dad for one child. Then we're going to do another child support calculation to see what dad would pay mom for one child, and then we're going to split the difference. That's how we're going to get to our final support amount. This gets really complicated if you also have maintenance involved and you also have other kids. You're going to have to do a lot of math, but this is the basic steps, right? What mom pays dad, what dad pays mom, and we'll split the difference. So this is where I want to talk about HFS's calculator real quick, because this allows you to do these calculations a lot quicker, and you can adjust the numbers ever so slightly and print out a bunch of different scenarios. So we're going to go to the same website. It's right here. You're going to click on this button right here. And now we're going to go to the right-hand side, and we're going to click on Child Support Estimator. Just be careful because there are 2 estimators. One is for parents, one is for legal professionals. The one for parents you'll see is right up here. I'm sorry it's so small, but I had to get the whole page. This is the parents one. It's a little bit simpler, doesn't have quite as much functionality to it, but it's a great way for parents to kind of get an idea of what their support obligation might be. The one for you is all the way at the bottom. It looks like this. It's also got a mobile version, which I highly recommend. So you can download it onto your phone, right, in a web browser. And even if you don't have Wi-Fi or internet access, it'll still work in the courtroom, which is a good thing. So we're going to plug in the number of children. In this scenario, we only have one child. Technically there's two, but we're just calculating what mom pays dad for the child in dad's care. And we're just going to stick in 365 because we are not going to do a parenting time split in this case. It's already complicated enough. I'm going to click the boxes for standardized net, because I'm doing this for my cases, but you would probably click the box for individualized, and then you would bring up these two spots where you could actually key in how much taxes each parent is paying. So we got their gross incomes. Down here, you are going to be required by the calculator to mention whether or not medical insurance is being provided. If you don't use this pull-down box, it will not calculate support. So I'm just going to click none for now, but you might want to say that it's provided or it's available, and the calculator will do something else. So when we're done, we're going to click the calculate button, and it's going to show us what support would be, which is great, but we need more than that. So we're going to hit the print button, and it's going to pull up the worksheet. So this is exactly the same as the worksheets I gave you as handouts, only it's populated everything for us already. This is a great thing to submit with your support order or with your closing argument to the judge to show how support was calculated. I'm not going to show you the whole worksheet. Just know that you can download it as a PDF and have it available, or you can print it.
Is there a foundation exception in the statute for getting these in front of the judge?
I think that the statute says that HFS's calculator is the preferred method of calculating.
Yeah.
I never have that issue.
Nobody
The judge
objects.
will just take it.
Okay.
Yeah. I've never seen anyone have an issue getting a child support
I
calculator.
think there's a presumption.
There probably is, or it's a demonstrative exhibit or whatever. The judges are going to want it.
Right.
They're not going to want to do the math themselves. So providing this is a good thing. I don't like the calculator so much for my caseload because I'm always changing these calculations when dad comes in and mentions, oh yeah, I got a second job, or I got this other kid. So I end up crossing things out anyway. So I do these by hand. But this is a great way to do it very quickly, especially in a split custody scenario like this, where you don't want to spend a whole hour doing all the calculations, because you can just basically flip the numbers real quick, right? That's what I've done here. All we've done is changed this entry point. Now we're saying mom is the non-custodial parent, dad is the custodial parent. So all I had to do was change two numbers, and now I can calculate the whole thing all over again without having to. So that's what I've done. So we have the two calculations. I've already done it for you, right? In the scenario where mom pays dad, her support is going to be $647 a month. In the scenario where dad pays mom, it's going to pay slightly less, and that's because I upped mom's income by quite a bit. Now we just do math. What does mom pay dad? What does dad pay mom? The difference? Mom's going to pay dad $243.31 a month. I find that people don't really accept this quickly. They assume that if I got one kid and she's got one kid, then I don't pay anything. That's not the case. And the law does require you, if you're going to deviate, to at least show what it should have been by the guidelines. So, at least in my opinion, you need to do this if you're going to enter a $0 support order. You need to at least have it in your order that we're deviating. Child support should have been $240, but dad has decided to waive that. You've got to put it in there so you can have your case be clean when you close it out. What do you think about that?
Could you go back to the input page, one before that?
This one?
Nope, the one prior. Thank you.
Oh, sure.
Okay. So here's the conundrum that I've had in some cases. So I'm running across these parenting orders where they just alternate weeks because dad wants to minimize the support. Okay, so it's alternate, alternate, alternate. So they're insisting that it's 50-50 and that we can't use this program because no one's truly a custodial parent. And you have that odd number of the 365 overnights. And I got to give one parent one more overnight, and that's going to change the equation, and that's going to change the support.
Right, I think it's 183.5 overnights or something like that. I just do it by hand, because then you can skip. The calculator is wonderful, but it does limit some functionality.
The other way to do it would, because of the odd number of days, is to run it, give dad the odd number, run the child support, give mom the extra day, run the child support, and then average the two. That's what we do in Lake County.
Oh, that's wonderful too. That's a good way to do it. We're not talking about much stuff. right? I can't imagine it moves the needle much. Is that at least it's a solution? I mean, I know the calculator is great, but I think knowing how to do this by hand is really good.
So the statute is ambiguous about whether or not shared care has to be by court order. It could just be, we have this informal arrangement, and then you're kind of in a place where you have to put testimony on.
You mean, I don't know. We could look at it when I'm done. I can't remember. For me, it depends on what county I'm in. LaSalle's pretty hardcore about, you gotta have a parenting order, and we're not gonna give you this until you come into my courtroom and we enter an order. Other places I practice, like Kankakee and Bureau County, they don't really care as long as we get an agreement. I don't know, what are your sort of experiences in other counties? Does anyone do this? Like you said, in Lake County, do they need a parenting order before they're gonna give anyone a deduction?
Well, I don't want to sound arrogant or anything, but in the cases that you're handling, maybe in the cases that I'm handling,
Right.
there are parenting orders.
Right, don't worry about something here. Yeah, I understand.
We're all
You're doing a
friends.
full divorce case. I'm just doing get child support as quickly and as accurately as possible.
Right.
So it's a different
Yeah,
practice.
but we do some parentage work, and the judges saying, well, I need to know that it's really your child, and that you're actually exercising the time.
So is that generally
Usually the parents don't disagree on that. I mean, they don't, in my cases anyway, the parents don't, usually they don't disagree on the parenting time.
Okay. And mine they do. A lot of times. All the time. Yeah, no one can. I had one this week in LaSalle where mom and dad couldn't agree where the child lived. Did they live with dad or did they live with mom? And we talked it out in the hallway probably for 30 minutes. And then I was like, you know what, screw it, we're just going to have a hearing. So we scheduled it for a hearing, I put him on the stand. I do all the dad's testimony, put mom on the stand, and she goes, yeah, child lived with dad. Oh, Jesus. Just wasting an hour.
Did you ask from which address is he registered for school?
Yes, and he brought a report card. So he did everything right. I had mom saying, no, the child is not with dad over and over again. So what am I going to do? You got to put her on the stand. I just thought it was funny that she switched as soon as she took the oath.
Sometimes raising your right hand
It helps, right?
brings out a different answer.
Yeah, it does. So I was going to talk about problems with income next, but does anyone have a question just generally before we move on? Okay. Yeah, go ahead.
One thing you had mentioned, you showed the shared custody scenario where mom owed dad like $200.
Yeah.
So it's possible that dad will just waive it.
Yeah.
You mentioned that you would want to mention in the order that you deviated from the statutory amount. My question is, if I represent mom, I don't think I want that in order. I think I just want to put that dad is paid child support or is reserved on child support.
Sure.
Is that?
I believe it's in the statute that if you're going to deviate, you must say what the guidelines are. But
Okay.
I only have one judge that I practice in front of who insists upon that. Every other judge does not care as long as it's an agreement, so they won't put it in. I think it's a good idea to have it in the file at least, in your back pocket, so you knew what was supposed to happen, but I've never seen an issue there. It's Judge Bernie in Bureau County. Thank you.
It doesn't require an order, it just says if each parent exercises 146 or more.
That's what I
rights.
thought. Okay. Yeah.
I've argued this for years. I don't like to reserve child support.
Okay.
I'd rather set it at 0.
So you can,
Because then you're come under 510
Right,
for a change in circumstances, and if you reserve it, it means it was never set, and you can just start fresh, and you don't have to prove a substantial change in circumstances.
Sure.
So my preference is, it's $150 a month, but the parties agree that it'll be $0 child support set at $0.
and then you can file, you can modify later on. Yeah, not have to serve them. Okay. It's good practice. I only got 10 minutes, so I really want to touch on problems with income, because you're going to see this a lot. Let's do 3 really quick. First one, Dad, we're going to keep Mom at $5,000. Dad only got $750 a month in income. Everything else remains the same. Just note that we're going to have 2 kids in this scenario. So we do have a minimum child support obligation part of the statute. And it essentially says that if Dad's legitimate income is 75% of the federal poverty guidelines, then you should pay $40 per month per child for child support. right? So I just want to quickly show you how you calculate this. These are the federal poverty guidelines for 2019, multiplying by 75%, divided by 12 months. We're talking about $780, give or take a little bit. So if this is dad's legitimate income, right? He's not voluntarily unemployed. You don't think he could actually go out and get a better job. He should pay $80 a month in this scenario because there's 2 kids. I don't want to get into this, but the worst part of this section of the statute is it also says that the maximum amount he can pay is $120 per month over the course of all of his cases. And I do not know how you would do this if dad has a $400 support order in Lake County. I'm in Kankakee County and going after him, right? I think what's supposed to happen is I set my $80 per month order in Kankakee, and then it's on him to go to the lake and modify down. The judges always ask me about that. I don't have a good answer for you yet because the appellate court hasn't been able to this. But the general idea is if dad has that limited income, and it's legitimate, the maximum amount he should pay is $120 a month, no matter how many kids he has. No matter how many more kids he has after that. He just keep adding more and more and more. He only has to pay $120 per month. Let's change this slightly, and let's say dad has now $771 in income, but it comes from SSI, so Supplemental Security Income. The reason I bring this up is that there is a portion of the statute that says if you have no gross income, or if you only receive income from a means-tested program, SSI, TANF, food stamps, you should not pay $40 per month. You should pay $0. And that also includes people who are medically proven to be disabled, incarcerated, or institutionalized. What I see most are incarcerated. So we will come in and zero out a person's child support obligation if they're in jail. The idea being, when they get out, well, it's political, it can go either way. The idea here is when they get out, we don't want them to have tens of thousands of dollars of support they can never pay back. If we do this, it's part of the statute. I don't think it's discretionary. The only ones I personally won't do is where dad is in jail for either sexual or violent crimes against the family. I reject all of those. I will not bring them in front of the court. Otherwise, we go in quite frequently. I probably do one a call where we're zeroing out someone's child support order because they're incarcerated. You can dispute the politics behind that, but it's in the statute. So in that scenario, dad only has SSI, so his support would be $0. Let's talk about the last one.
On SSI, is there a dependence allotment for the child?
I don't think so. That's SSDI. So if you're getting disability, SSI is basically saying this person is incapable of supporting themselves, so the government is going to give them around $750 a month to survive. Yeah.
Have you ever come across a scenario where an incarcerated person still is receiving business or rental income or some kind while they're incarcerated?
No, but I do have moms come in and say, well, he's got money in his commissary account. He should pay support off of that. To which I say, it's $10 a month. You need to just let it go. Yes, sir. Did you have a question too?
No.
Oh, sorry. Yeah, so no, I've never seen that. I do have one right now that I'm working on where dad is about to get a pension from a carpenters union. It's a significant pension. That's his only source of income, and he's in jail until 2033. So I'm trying to find a way to get access to that.
Well, if you go back, it says rebuttable presumption. So I just gone in there and say the presumption is based upon these categories if someone's not earning money, but if there is money coming in, you can rebut the presumption.
Exactly. It's not a shall. You're right. But to get past that rebuttable presumption, I've never seen someone successful. But you'd have to have special facts like rental income or business income. Let's talk about the last scenario, the one I see probably the most. Dad's looking for work. He's been looking for work for 6 months, and he just can't pay support right now because he doesn't have a job. We're going to keep everything the same. Mom's doing well, $5,000 a month in income. Standardized net, no maintenance, no other kids. We're going to have 2 children in this scenario. So we do have a portion of the statute that talks specifically about people who are unemployed or underemployed. It's got to be voluntarily unemployed or underemployed. And it gives you the ability to impute income on people in this scenario. This is a powerful, powerful tool, and I use it quite a bit. These are the factors you need to sort of touch on. It's right in the statute if you want to impute income on someone. So the ones I generally use are the person's work history and their occupational qualifications, right? What have they done in the past? What are they actually qualified to do? If you got a guy who didn't graduate from high schools, never held a full-time job, you're probably going to be unsuccessful in imputing much income. On the other hand, you got a guy with a college degree who used to work a lot and now has decided If he doesn't want to work anymore, you have a very, very strong chance of imputing income on him. The most interesting one, I think, are out of the factors is an ownership of a substantially non-income producing asset. I've had 2 of these, and they were always cars. So I had a guy who owned a truck for work. Well, he wasn't working, but he owned a truck, and he owned a Harley. And another guy who owned 5 cars. They weren't nice, but he had them. The idea here is that there is an asset that this guy can sell to pay child support. And I like this a lot because it makes judges feel much more comfortable ordering someone without a job to start paying child support when they know there's assets available that they at least could sell to start paying. Generally, though, this is just a big motivating factor to have someone go out and get a job. But the factors are important, and I think if you're going to do this, you should try and touch on all of them in testimony. Work history, occupational qualifications, what's going on in the community, are there actual jobs, right? In the downturn, this was probably very difficult because people legitimately looking for work couldn't find jobs. Now, it's much different. In the counties I work in, you can go to a warehouse and get a 13-hour per hour job pretty quickly with limited abilities, right? But that might change depending on the economy. And the earning levels in the community. I never hit on this. I think basically what we're talking about is what is this person likely to earn based on who they are and who they used to be. So what will dad support be? I don't know. It's going to be what you can prove up to the judge. I find my judges to be a little bit conservative, so I tend to overshoot. I'll ask for $20 an hour, knowing that the judge is going to come down a little bit. That's just because I know the judges I'm in front of. You might want to be much more of a straight shooter, I don't know. But I think discovery tools are really good in this scenario to find out what they've done in the past. You want to look at old paycheck stubs, old tax records, all that stuff, so that you can support whatever number you're going to suggest to the court. There's a lot of stuff there. Let's talk about modification very quickly. I'm almost out of time. Just a quick scenario. In this scenario, dad lost his job because of corporate restructuring, right? It's a legitimate reason for losing a job. He didn't quit it voluntarily to get out of paying child support. He lost his job and he's receiving unemployment benefits. So we have a different section of the statute that talks about modifications, 510. What we need to really focus in on are these key words. You have to show a substantial change in circumstances. I'm going to go fast because I'm not on time. What is a substantial change in circumstances? It's a big life change that was involuntary, right? Something happened in your life that was out of your control, and now you don't have as much income as you used to. That's fine. So an involuntary loss of employment, an involuntary change in income, they reduced your hours of work. You don't have control over that. Emancipation of a child, birth of a new child, these big life changes, that's when you have the right to come into the court and ask for a modification. What you don't have a right to do is come in because the law has changed. That's actually right in the statute. Because you quit your job to start a business, you cannot voluntarily reduce your income and expect the court to modify your child support, right? You are going to be imputed what you used to make in the past when we set support now. Passage of time also doesn't matter. I have guys come in all the time and say, oh, it's been 10 years. It's time to readjust things. That's not good enough. Also, what I see the most, and which really gets me mad, is challenging a default order. So the guy was properly noticed, we set it for hearing, he didn't show, I entered a default. A couple months later, he files this motion to modify saying, I'm not working, and he wants a modification. That's not good enough. He had his opportunity and he blew it. Because the change is supposed to be from the date of the last court order. So if he was unemployed when I set my default, and he's unemployed today, he is SOL. He missed his chance. Now, that's my take on it. Sometimes my judges are a little bit more kind to these people, but I'm going to argue that the court should not be giving people multiple chances to modify their child support over and over again when they fail to show after proper notice. So in this scenario, what's likely to happen is we're going to reduce child support down to his unemployment benefits amount. We're going to place him on a job search, and he's going to have to come back to court on a regular basis, proving up to the judge that he's legitimately looking for work, and when he finds work, we will recalculate this child support.
Can I say 2 things about this?
Sure.
Unemployment. So unemployment, I think if you're in a situation where you're representing a parent and the other parent wants a modification because there's a change in their income and they're receiving unemployment, you can skip the step, I think, safely about whether or not this was a voluntary or involuntary change in circumstances, because unemployment already does an analysis about whether or not the person was fired for cause or not. So if you're awarded unemployment another agency has already looked at the circumstances or the employer hasn't challenged the person seeking unemployment, so I think it's a pretty safe bet, unless mom has some other, evidence.
Sure.
And then for unemployment, you have to do job searches. And so if you have parents that are complaining about having to do job search and then come back and approve it, they're already doing it. So all the burden that you're putting on them is an extra court date or two to come in and show essentially the diary that they're doing for IDES as well.
The only scenario in that sort of situation where I have problems is when dad is a seasonal worker and goes on unemployment for the winter and goes back on regular employment for the summer. I don't think he should get modification. What I generally ask the court to do is an average of the last 3 years, taking into account unemployment and seasonal work. So I don't think we should be cutting back every single season. Let's do health insurance really fast. I'm almost out of time. 1 minute. Let's do it really fast because it's something you should know, right? I'm just going to skip ahead. And we're just going to talk about it real quick. First thing you need to think about is the amount of health insurance the person is providing. Is it a reasonable cost? There's something in the statute to tell you exactly how to do that. It's 5% of your gross. So if the cost of health insurance for the payor is more than 5%, you have an argument that it's an unreasonable cost. Also, if the person's net income, net is important here because the last time we used the poverty guidelines, it was gross. If net income is less than 133% of the federal poverty guidelines, so that's about $1,400 a month. In this scenario, dad's income is about $2,300 a month. If he's below that point, the statute says he should not contribute to health insurance. So take those two numbers to heart. Here's how you do it, right? I'm going to make it real simple. We're going to say dad is providing health insurance for the child at $100 a month, right? So mom needs to, under the statute, contribute to that cost. And we're going to figure that cost using the income shares model. So what we're going to say is, since mom has 50.44% of the income, right? Her share of that premium is going to be her percentage share. So $100 times her 50% of the income. So she's going to pay $50.44 per month towards that premium. And that premium is only for the child. What we do is rather than have mom send dad a check and dad send mom a check for child support, we just take it off the top of dad's child support obligation. So we take out mom's share of the medical from dad's child support obligation. There's a little bit more to that, but that's the basic. That's all I got. Thanks so much.